Welcome back to the Golden Years video series blog, where we outline the emotional and financial journey of caring for loved ones who are not able to handle their own affairs and manage their own care. My name is Michael Baratta, President of Fortress Brokerage Solutions. Fortress Brokerage is an insurance distribution organization that assists independent agents and consumers with life insurance, long-term care insurance, annuities, and disability income products. I want to begin with the first step, managing and organizing the decisions surrounding our life in our golden years. We call this the plan. The plan includes a number of legal documents which govern and appoint particular people to administer affairs due to incapacitation, the way in which you would like financial and medical treatment to be handled, and the management of the estate at mortality. These documents include the financial power of attorney, the healthcare durable power of attorney, revocable living trust, and advance directives. Don't worry, we provide you with the capability to easily set up all these legal documents that are affordable and do not require the use of an attorney. I will circle back around to this. You must first identify who you want to appoint to hold the responsibility as your power of attorney. We call this a POA. This should be a person or institution that you vehemently trust to carry out your personal desires and wishes. They can be responsible for your financial, health, and well-being. Once identified, you need to have a discussion with that person so that they understand and accept the responsibility. It is important to understand that you are not giving up your control today. You are appointing somebody at a point in time in the future to handle your affairs by some triggering event. An example of such an event might be a coma, dementia, Alzheimer, or an accident rendering you unconscious or unable to articulate your desires. Whatever the incapacity, your trusted person will need to have control to make decisions on your behalf. The POA will do just that. This is a legal document that must be drawn up, signed, dated, and notarized to be effective. Typically, a spouse can act in health matters, but perhaps not financial matters depending on how accounts are being titled. A parent can act on behalf of a child under the age of majority. Age of majority is 18 years old, where they are a responsible party by law. Without a prepared POA, the state may determine that they are responsible for your well-being. If the designated party indicated on the POA is unable to handle your affairs or decides that they do not wish to maintain this responsibility any longer, a designated contingent POA will be your responsible party. All POA documents should indicate both the primary party as well as the contingent party. You may also add language qualifying the designated person as your POA. For example, the designated person must pass a drug test or something similar to that. So again, there needs to be two documents: the financial power of attorney, which provides the capacity of the chosen party to handle financial affairs, as well as a healthcare durable power of attorney, which provides the capability of the chosen party to handle medical decision, treatments, and overall well-being. The financial power of attorney provides the authority for access and handling of financial matters such as, but not limited to, property, bank accounts, business transactions, litigation, taxation, and so on. It is important to have a list of assets, account details, contact information of financial institutions, ongoing bills to be handled, and maintenance on properties, information on business dealings, insurance policies, lenders, and more. All the items which you would normally handle yourself will need to be performed by your POA. So they need to have an accounting of items you would need them to be responsible for. This list should be updated frequently and kept with the financial power of attorney paperwork. The healthcare power of attorney gives authority to make decisions regarding one's health, such as but not limited to health insurance, medical treatment, medical payments, HIPAA-protected documents, and more. A hospital will need to have this document on file if a circumstance occurs that triggers the healthcare power of attorney to be valid and effective. So it is important that your designated party has access to this paperwork when necessary. The hospital may also request a copy of the Advance Directive. This is another legal document which provides instruction for medical caregivers to carry out your wishes and desires in the correct fashion. The POA document may be revoked or changed any time you wish. For either the financial or the medical power of attorney to be in effect, the designated person will be required to have certification in writing by the medical professional which confirms the inability to make these decisions for yourself. Fortress Brokerage is proud to offer you the ability to easily and affordably set up these documents yourself. Our trust and estate planning software has been built with the help of attorneys in each state to maintain specific legal language for each specific state on these documents. You can start the process today and have it completed with a notary tomorrow. Attorneys can be expensive and can drag out the time it takes to prepare these legal documents. Additionally, if you ever wish to make changes to these legal documents through the use of the attorney, restatements can be expensive. With our professional software, you can fill out your own documents and make changes to them when you wish for no cost at all. We have provided this as a solution to everyday normal people because we know how important it is to have these documents prepared, and that dealing with an attorney for such a task can be costly and take a lot of time. Once these documents are prepared, the second step to this process is to provide the designated person access to this paperwork. It is crucial to notify your power of attorney where these documents are located, how to access them, and if changed, that the POA is made aware and can access the most up-to-date version. Our online trust and estate planning software contains a protected vault where these documents can be generated and uploaded so that your POA can access them if necessary. Additionally, hard copies should be kept somewhere accessible and secure. Take a quick look as we fill out financial and healthcare powers of attorney documents, which you can do through our online trust and estate planning software.
In order to complete your revocable living trust, power of attorney documents, advance directives, and will, you will need names, phone numbers, addresses, email address, and dates of birth for your beneficiaries, trustees, and power of attorney agents. You may begin the process of filling out your documentation by clicking on the Your Information tab. The software has been formulated to match the specific legal language of your state to ensure its validity. As you proceed through the estate plan software, you will notice blue question marks. These question marks provide additional information and detail as it relates to the specific question you're working on in the platform to ensure that you choose the best option that meets your needs the closest. The green check marks indicate your completion of all fields in the Review tab. A red X means that you must go back to that page and complete the missing data. Once you have completed all of the data fields, you can generate the document where it will be time and date stamped. It is highly recommended that once all signatures and notaries have been completed, that they be scanned and uploaded to the document screen to ensure the time and date stamp. The funding kit is vitally important to finishing your trust. To fund your trust, you need to go through the asset titling process. There are two types of assets, real estate and then everything else. Changing the titling of your real estate may sound tricky, but our system provides a streamlined approach to ensure that this process is done correctly. Using DeedWorks, a national deed preparation organization, you can commission a professional service to handle the changing of your titling to your deeds without the hassle and headache. Simply use their online service and they will handle everything for you. All other assets will indicate how to properly handle items like bank accounts, vehicles and boats, insurances, retirement plans, pensions, business interests, and more to ensure that all your accounts will be inherited by the individuals of your choosing. Once complete, your trust and private documents may be updated when you wish for no additional cost. Our trust and estate plan online software was built to help normal everyday Americans protect themselves, their families, and their financial livelihood.
If you wish to take advantage of our online POA software through our free trial link, or if you wish to have a member of Fortress Brokerage team assist you through this matter, you can call us at 678-322-3040. The plan that you create with your advisor or utilizing our legal software platform is the formative step to ensuring that you and your loved ones will have a course of action set in stone to live dignified through the golden years. Thank you.